सब सही है ना? हाँ हाँ ठीक है, मुझे भेजो। तो सिस्टम पे सही कौन है सिस्टम? हाँ मैं वर्टिकल लैंडस्केप में कोई दिक्कत नहीं ना? ठीक है डन। क्या फिर चल रहे दो आराम से? और लाइट मोड, हाँ मैं प्रिंस को बोल के रखा हूँ, जो मत बताया। चलो ठीक, अभी निकल रहे हो? चलो जब जाएगा तो बता देना। एक ड्रॉप कर दे, फोन ही चलाऊंगा। हाँ ठीक है। कोई और नीचे जगह है, सीढ़ियां है। इधर आजा पायल। उठा देंगे
I request Mr. Nishant and Rajat Machinda, member executives, to please escort Justice Ohri to the dais. I request Mr. Mohan to please escort our president, Mr. Mohit Mathur. Jatan sir, please. Indragiri Singh Alag sir. I request Sanjay Diwan sir to please escort Indragiri Singh Alag sir. Now I request everyone to please rise for recital of preamble of Constitution. Thank you so much. Sorry for the technical glitch. Our apologies. Mr. Mehra will apologize to everyone personally. Now I request Mr. Mohan to present to Honorable Mr. Justice Manoj Kumar Ohri. I request Mr. Mrityunjay to present a shawl to Honorable Mr. Justice Manoj Kumar Ohri. I am holding in my duty. I will not mention Mrityunjay Kumar Singh ji has been helping us to execute this program. He was actively involved. I thank you, Meti Bhai. Now, Vice President Japan Singh sir to present a memento to Justice Ohri. Request Mr. Nitesh Mehra to present a planter to our charismatic President Shri Mohit Mathur. Now I request Mr. Kumar Singh to please present a shawl to our young and dynamic President Shri Mohit Mathur. I request Senior Member Executive Shri Sanjay Diwanji to present a memento to the Father of the Bar, Shri Mohit Mathur. Please, I request everyone. Now, I request our Member Executive Rajat Manchanda and our Member Executive Gayatri Puri ma'am to present a planter to Honorable Mr. Justice Kushendra Kaur. I request our Treasurer Mr. Sakshya also to present a planter to Justice Kaur. I welcome our former President Shri Kirti Uppal, Senior Advocate. Thank you so much for coming, sir. It takes me immense pleasure to welcome you all to our Learning the Law series, an initiative of Delhi High Court Bar Association to impart education, promote the learning of law, and share the wealth of knowledge with the members of the bar. On this note, it takes me pride to welcome all to the second Learning of Law chapter, Bharatiya Nyaya Sanhita 2023. With this auspicious start, I would now request Mr. Jatan Singh, our Vice President of Delhi High Court Bar Association, to give the welcome address.
Thank you, Veni. Honorable Mr. Justice Manoj Kumar Ohri, today's keynote speaker on the issue of the new law, and Mr. Justice Kumar, Mr. Mohit Mathur, President of the Bar, Mr. Veni, the officiating secretary today, Mr. Inderveer Alak, Senior Advocate, members of the Executive Committee, ladies and gentlemen. A difficult task has been bestowed upon me to fill in the shoes of Mr. Mohit Mathur, which is a difficult, very, very difficult task, because it is his position which I have been asked to speak. It's a president's address, which is always given by him. So, to emulate him, to act like him, and to speak like him is not an easy task. So, thank you very much, Mohit bhai. Today you have given me a chance because you are another keynote speaker. So that gives me an opportunity. You all know that Delhi High Court Bar Association has been conducting, organizing sports tournaments, seminars, photography exhibitions, and all sort of activities which encourages the members to come and participate. And this lecture series, which was just thought of 2 months back, that we should start some educative lecture series. So the first one was a very big one, but this is the biggest one. The first one, there was some space available in this hall, but today we were just discussing that with Justice Ohri and Mr. Mathur and the kind of object we are hearing, I think they fit in everything, and that's why members have come in the large numbers to hear them on this Bharatiya Nyaya Sanhita, the Indian Penal Code, old one. So, अभी हमें आदत नहीं पड़ी ना, जुलाई होगा, तो ये जो आदत डालने के लिए ही अभी ये जो डिस्कशन है, जो लेक्चर सीरीज है, ये हमें आदत डलवाने के लिए ही रखा है. तो आई होप दैट the kind of speakers we have, you will all enjoy and you will all learn the nuances and the new provisions which are there in the this new code. And I would end my speech with one of my famous couplets, which otherwise won't be possible. Though I have requested Mr. Alak to say a vote of thanks, but he'll be saying it. But I will not hesitate to say it again. So, बड़ा अच्छा जो है बाबा नानक के शिकवा शिकवा नहीं शुक्राना सीख गए, शिकवा नहीं शुक्राना सीख गए, तेरी संगत में खुद को झुकाना सीख गए. पहले हो जाते थे कुछ ना मिलने पर, पहले मायूस हो जाते थे कुछ ना मिलने पर, अब तेरी रजा में राजी रहना सीख गए. I welcome Jasmeet Singh, and now thank you very much.
Thank you so much, sir, for setting the tone for evening. Ladies and gentlemen, we are honored to have with us our guest of honor of the evening, Justice Manoj Kumar Ohri, Judge, Delhi High Court. I heartily thank Justice Ohri for always being so supportive and encouraging our members in all activities with his presence and again giving us his precious time by gracing today's occasion. We request you kindly share your words, sir. Justice Ohri.
Mathur.
I request our lady member executive Vandana for approval to present the planted to honorable messages with the speed thing. I request Mr. Amit Jetta to join Vandana.
Till they sort this out, I'll start with my thanks. My esteemed colleagues present in the audience, Mr. Mohit, Mathur, Mr. Alay, Mr. Latan Singh, Mr. Benipal, members of the senior advocates, members of the bar, ladies and gentlemen, a very good evening to all of you. I must begin by congratulating the DHCBA in taking this initiative for organizing this series of learning the law of justice. Today's topic is Bharatiya Nyaya Sanhita or BNS that is going to replace IPC in July 2024. I'm glad that I've been given this opportunity to share my views on this transformational event we are going to experience in the near future in the entire country. I also wholeheartedly share the enthusiasm of the Chief Justice of India in welcoming the three new legislations. The primary aim of any criminal justice system, besides providing career options to young lawyers, is to the protection of the rights of personal liberty against invasion by others, to protect the rights of the citizen, the states prescribe the rules of conduct, sanction for their violation, machinery to enforce these sanctions, and then procedure to protect this machinery. Many of you might be thinking what was the need for bringing Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Sakshya when IPC, CRPC, and Evidence Act were there. The criminal justice system needs to keep pace with ever evolving society, especially the digital world. With passage of time, growth of technology, and change of social landscape, crime has acquired new form. The existing system, being century old, was found to be ineffective, with delays in trial, lesser rate of conviction, and piling of penalty. To this, I must include the efficiency of our criminal lawyers. Law should not limply, I 1972 English decision. Law should not sit limply while those who defy it go scot free, and those who seek its protection lose hope. Malimat, led by Justice V.S. Malimat, was formed in the year 2000. It was formed to recommend reforms in the criminal justice system. Later, another committee was tasked to prepare a draft national policy on criminal justice. This committee was headed by Professor N.R. Madhav. In his recommendations, this committee suggested recategorization of offences under the various chapters of IPC. The experience of 30 years bar and now on the bench say without hesitation that while some existing laws were obvious, but still sometimes a need was felt to have a clearly etched out definition and provisions in legislation itself, rather than rely upon divergent interpretative views of various courts heading to the criminal laws definitely required a relook to make them more updated with the technological advances and plug the gaps that impede the smooth delivery of the justice. Today, I will not discuss my interpretive views on the specific legal provisions enacted in these new laws, since I think that left to the courts to examine, and also for the reason that tomorrow you may enter me in those cases while I am having a different view. The BNS, which is the topic for today, has incorporated all those recommendations which have been suggested by the most of the recommendations which have been suggested by the two committees, as well as some more from the stakeholders. I'll start with the unique nomenclature of BNS, Bharatiya Nyaya Sanhita. It has substituted the word Indian with the word Bharat and penal, which means done, with Nyaya, bringing a sense of indigenousness which was not the case of IPC. This shift also showcases that focus of the law would be now upon securing justice to all stakeholders instead of only imparting punishment. The changed nomenclature further represents a conscious shift in the Parliament's understanding of the law as reformative instead of deterrent or retributive. Now, if we look at BNS as a whole, it would be noticed that large portions of IPC have been retained as verbatim, considering that they have withstood the test of time At the same time, portions which have become redundant have been completely removed, and with the need of our certain new sections offences have been introduced. The IPC had 511 sections. The BNS has only 358. The first major contributing factor to this simplification has been the putting together of definitions of various words like man, woman, person in section 2, new section 2 under one clause. Earlier, in the IPC, we had this definition ranging from section 2 to 52A. Another crucial development is that BNS now defines what is child under section 2, subsection 3 as any person to the age of 18 years. This development becomes crucial in light of the fact that previously in various sections 82, 83, 361, 366A of the IPC, they used various terms like child, minor. Now the minor has been defined to be with respect to a boy to be less than 18 or a female less than 16. Now this differential for the ages has also been removed. Now the one child is everyone below the age of 18 years. Supreme Court passed a ruling in Nalsa versus Union of India with respect to rights of the transgenders. Now the definition of this transgender as third gender, and this definition has also been incorporated in line with transgender persons act by reference to BNS definition clause relating to the word gender. Certain definitions which were existing in the IPC have been now broadened. For example, document in section 2A, new section 2A includes electronic and digital evidence. Definition of the term movable property in again, the definition has been expanded by removing the word corporeal. It has also been clarified that any word not defined in Sanhita and defined in BNSS or Information Technology Act would be having the same meaning. The inclusion of the IT Act in this BNS shows that there is a close nexus that is sought to be created between BNS and IT Act in view of the digital space being used as a tool for commission of offences. Another hallmark of BNS is that provisions have been substantially reorganized and rationalized. Offences against women, especially children, have been taken very seriously under the Sanhita, and stringent provisions have been made in this regard. Women and children have been put under single chapter, chapter 5, while IPC, the offences relating to women and children were scattered all over. Another thing is false promise to marry. So far, the sexual intercourse on the pretext of false promise to marry was covered by provisions of rape, as established several decisions of the Supreme Court. Under new section 69 of this Sanhita, a distinct provision has been incorporated in this regard. Section 9 provides that interpreting to rape is committed on false promise to marry or by deceitful means, the same would be punishable. The definition section deceitful means is also defined in the provision. It provides that it can include an inducement for promise of employment or promotion or marrying by suppressing identity. Another section 792 of Sanhita deals with gang rape of women under 18 years of age, which is an aggravated form of gang rape. Under the IPC, there were two provisions relating to rape of women 16 years of age and under 17. The same have been now amended and the age, and this is also from 16 to 18 years. Now the offence entails death penalty, which earlier was only in the case victim was under 12. We also divisions with the decision of Supreme Court in independent thought, where exception 2 to section 375 was read down. The exception 2 to section 3 of BNS now reads the age criteria as 18 years instead of 15. Significant. BNS also marks a departure from archaic terms like lunatic, insane, idiot, which had the tendency of lowering a person's self-respect. Now, all these words have been by a more somber phrase, mental illness. Another significant change that can be seen is for the aspect of punishment associated with the offences. It will rationalize punishment imposable for certain offences which at times were found inadequate. Several changes have taken place. A comparative analysis of Sanhita with the IPC would show that for 33 offences there is an increase in punishment. Offences like commission of offence by public or more than 10%, buying child for the prostitution, voluntary causing hurt or to deter public servant from his duty, certain aggravated forms of wrongful confinement, exploitation of practice. Almost in 83 offences, now the fine has been increased. The offences like voluntary causing hurt, voluntary causing hurt or grievous hurt by dangerous weapons, illegal payments in connection with elections, making or using resettling currency notes or bank notes as well. Under the IPC, minimum sentence was provided for offences like rape, dowry death, and certain aggravated forms of robbery like Section 397. Under Sanhita, such mandatory minimum sentence has now been as many as 23 offences. These offences are child for the purpose of prostitution, culpable homicide not amounting to murder, impersonation of a public servant, dishonest appropriation of property, etc. Now, in line with the reformative approach, the punishment of community service has also been included as a form of punishment. Right now, it is restricted to only 6 offences, which are non-appearance in response to a proclamation, attempt to compel or restrain exercise of lawful power of public servant engaging in trade, petty theft, or return of theft money, misconduct in public by a drunken person. Certain issues, however, imposing a punishment of community service would lead to certain interpretation. The aspect of what would fall within the definition of community service. Another issue would require committee or body would be empowered to supervise as punishment is duly undertaken. Another section which requires mentioning is new section 73 of the Sanhita, which makes the act of publishing or printing any matter in relation to court proceedings in the way. Earlier, this section was not there. Now, proceedings of court has also become an offence when it is without permission of the court concerned. Experience has shown that minors children were often used for commission of. We have seen over the period of years that minors juveniles would be hired to carry out the offences so that they can walk away with minor punishment. While the minor child would still get the benefit of his being minor, not being like the law. The only way of making the person motivating or hiring such minor child to commit the offence is by way of abatement provisions. Now this has been specifically addressed under section 95. BNS also recognizes judicial pronouncements by over a period of years. In this regard, it may be noted that section 497, which criminalized adultery, section 370 dealt with unnatural offences, have been done away with, consequent to Supreme Court striking down 497 in Joseph Shine case and partly watering down section 377 in Nafte Johar. In Nafte Johar, the section 377 was only watered down to the extent that it excluded from its coverage in relation between two consenting adults. Now 377 in BNS has been completely removed, leaving for the courts to now to interpret unnatural offences for two adults, which would require some technique. Section 309 in IPC provided for attempt to commit suicide. A lot of concern was that it has to be that this section 309 the person is under severe stress and he cannot be punished for this offence. Section 115 of the this renders section 115 of mental health as redundant. Now this section has been removed. Rather, a new offence has been incorporated under section 226. This is when a person attempts to commit suicide with intent to compel or restrain public servant from discharging his official duty. The how this section plays out in practical situations, especially in light of 115 of the Mental Health Care Act, is to be still seen in the future. Another significant change which has been brought in Sanhita is everyone remembers section 303. Person already facing a life convict if he commits another offence of murder. Section 303 was done away with by the Supreme Court in Mathur. Section has been reintroduced of section 4 in BNS. Another section has been added where a person, because of grievous, was left in a vegetative state. There is no provision for that. Now, section 117, bracket 3, is takes care of this. Section 308, Death by Ration Negligence Act. While the provision has been retained in Sanhita, now three different categories have been made. In cases of such act by dogs, the punishment as impossible under IPC has been retained. In other situations, punishment has been enhanced to 5 years. Further, the situation of cases which has been separately provided under subsection 2, the same is yet to be enforced. Just it is not enforced. Even in cases, punishment is, I believe the government is still talking about it. Now comes modern terrorism. BNS, unlike IPC, includes specific organized crime, for instance. So far, states sought to tackle this organized crime through legislation like MOPOCA. MOPOCA, enacted in state of Maharashtra in the year 1990, was adopted for Delhi in the year 2002. There was no central overreaching criminal. This is addressed by BNS in section 111, which defines crime as any continuing lawful, unlawful activity, including land grabbing, cybercrime. It involves use of violence, intimidation, to obtain direct or indirect material benefit, including financial benefit. This section clarifies what would amount to continuing unlawful activity. This inclusion becomes more prominent as for the first time a central law has been provided, defining what are economic offences. Although the same has been defined in the limited context of organized crime. Further, membership of any organized crime syndicate has also been punishable with BNS. By bringing the organized crime within the fold of BNS, it is safe to say Parliament is ensuring that the same is addressed across the country in a common and coherent manner. Further, in order to address certain anti-social activities like unauthorized betting or unauthorized selling of tickets, examination papers, BNS incorporates the offence of petty unorganized crime under section 112. Another aspect, terrorism, modern day crime which plagues not only India but all nations. Section 113 of BNS seeks to address this problem by stating any act committed with the intent to threaten the unity, integrity, sovereignty, secure economic security of India or strike terror in people, section of people by way of certain acts like use of bomb, dynamite would fall within the fold of terrorist activity. It is interesting to note that acts against persons as well as property have been included within the fold of this provision. It should also be noted in this regard there exists an overlap with UAPA, unlawful activity prevention act. Inasmuch as terrorist activity has been defined in a similar way as it is in UAPA. To overcome this conflict, it has been clarified that in the Sanhita that an officer not below the rank of superintendent of police would decide as to whether to register the case under BNS or UAPA. Membership of any organization involved in terrorist activity has also been made punishable. I am sure giving leverage to a superintendent of police would call for some litigation. The issue of mob lynching has also been addressed in Sanhita, which became a menace to the extent that even the Supreme Court asked the Parliament to enact a new law in Tehsil Poonewala case. Two provisions of BNS relate to Section 103 and Section 117. While 103 is with respect to murder, 117 is for the aggressor. These provisions cover situations or grievances on the ground of race, caste, community, sex, place of birth, language, personal religion, or any other similar ground. The use of word any ground leaves much to desire. By incorporating the term other similar ground, the VNS ensures that factors which may come to light later on the ground are also covered. Exact contours of this system would require interpretation. Moving on, perhaps the most debated provision of the IPC has been one relating sedition. While judicial pronouncements have clarified that aspect of sedition, the same was continuously riddled with allegations of misuse. Considering all this, Supreme Bombardere, while asking the central government to reconsider the sedition law, put the same on hold. This highly contentious offence of sedition has now been removed from BNS. However, uh, another offence titled X endangering sovereignty, unity, and integrity of India has been under Section 152. What makes this provision from sedition is that it has led to the shift concept from the concept of Rajdrah to Deshdrah. Unlike the offence of sedition which was committed against under BNS, offences committed against India, the nation. The provision certain open-ended and broad words like secession, subversive activity, separatist activities that would also require interpretation in times to come. Another interesting change that comes in the form of Section 197. While retaining the word of Section 153B of IPC, new subclause D has been added in BNS, which provides making, publishing of false or misleading information jeopardizing sovereignty and integrity or security of India would also be noted. The provision is aimed at tackling the spread of information detrimental to national interest. Some other changes in Sanhita which are abatement of offence committed in India by a person outside India has been made an offence under Section 48. Earlier, this was not a offence. Snatching has been incorporated as a distinct offence. Section 77, assault with intent to destroy, and Section 77 have been made gender neutral for the offender. Importation of person from foreign country has been made neutral, gender neutral under Section 1. Beggary has been included as a form of exploitation for trafficking and made punishable under Section 143. With such drastic change in overall criminal justice system as a necessary sequitur, a question may arise as to whether the old judicial decisions and pronouncements would hold any value once the new provisions come into effect. In this regard, should be noted that as stated in the beginning, majority of the IPC provisions have been retained with verbatim or with minor changes. On the question whether the precedent would continue to have a value, we have enough case law in the form of Bengal Immunity Company versus State of Bihar, wherein it was observed that when a statute is repealed or reenacted, the words in the repealed statute are reproduced in the new statute. They would be interpreted in the same sense as was put on them under the repealed act. This flows from the assumption that at the time of passage of the new act, the legislature is aware of the interpretation put on the provision. Consequently, the Parliament decides to retain the same. It would lead to the conclusion that judicial interpretation is accepted. This observation has since been considering the same. It would be apt to state that judicial interpretation and decision passed in respect of IPC would also be applicable to BNS insofar as provision has been retained. Over the years, the IPC provisions have been ingrained so much in our lives that even cinema has not remained untouched. Movies like Shri 420, Section 375 are titles of the various films associated with the IPC. The new generation which is going to read BNS is going to have tough time understanding these movie titles. There is no Section 420 in BNS. Perhaps the directors would like to rethink about naming these movies. With this, I end by. I must say that I am with new BNS coming, especially with these new provisions. I am as much as a student as you are. Thank you, everyone.
Thank you so much, sir, for bringing forth wealth, knowledge, and a fresh perspective that undoubtedly left a lasting impact on all of us. Apologies for the technical glitch today. I'll be failing in my duty. I will not acknowledge the role of Shri Narendra ji, Mrityunjay Kumar Singh, our member executive Nitish Mehra. They have worked really hard for this session. Now I'm delighted to welcome our expert speaker of the evening, the man who needs no introduction, our very own charismatic father of the bar, Mr. Mohit Mathur, senior advocate. We invite you, sir, to the floor to share your words of wisdom.
Good evening, everyone. Honorable Justice Ohri, the honorable judges who had joined us, and we miss them now. They had their cup of coffee, kept us amused for some time, and then perhaps felt, let the criminal side be left to the people who enjoy it. Mr. Jatan Singh, I'm thankful to him for not just substituting me in the welcome address, but showering so much of accolades, though I have always enjoyed the love and affection that he has always given me as an elder brother. Thank you, Gogi sir, who Mr. Inderveer Singh Alag for everyone. Since he thought that perhaps when Justice Ohri is giving us an enunciation of the new Bharatiya Nyaya Sanhita, who will take the other podium from the right to the, but fortunately for the audience, I am the right. I am really grateful to everyone for joining us today in our endeavor to analyze this new Bharatiya Nyaya Sanhita. And though Justice Ohri was very cautious and said that let the interpretations be left to the situation when they come, I, for one, will not mince my words. Since I would be doing it later, and I would always want all of my fraternity members to take such challenges and take up the issues which this will throw, in my humble submission. This we had culled out for the only reason that many would not recollect. The photograph on the left is that of Mangal Pandey, who, because of the Sepoy rebellion, caused the British to think about framing this IPC. I don't know who was the Mangal Pandey now in 2023, who forced the government to rethink about these statutes. Justice Ohri has already taken through all these salient features in details, but a couple of things which I'd like to point out. While the section 26 has been added, 377 of the old IPC removed, there is a grey area. Also preserves the vulnerability and protects the vulnerable below the age of 18 years. But it will have to be examined what will be the status of men above the age of 18 years in case of their sexual assault. Removing 377 after Navtej's judgment also really leaves a lacuna somewhere. We are protecting the women who have to be protected because that's the Param Dharma. However, when bestiality and homosexuality and sodomization is being removed, what is and what was acceptable was the changing society in accepting homosexuality, but that is in cases of consensual relationship. So one will need to examine what will be the status of cases where a man suffers a sexual assault, a man above the age of 18 years. That is one challenge which we as students of law and the judges as guardians of law also need to understand, examine, and not leave it to the cases of simpliciter, hurt, or previous hurt. Because this was a step altogether. Justice Ohri has already taken all of you through the aspect of cases where the offences, the sentences have been increased, and hit and run case or rash and negligent act as 304 as we remember till 30th of June. This aspect we would find that now with the different law commissions, these sentences were with increasing road rage cases, etc. That hit and run cases have been now put under a category where 5 years sentence is given, and they have recoined the hit and run as where you do not provide him the care. Even the last bullet, that mandatory punishment has been introduced for 23 offences, was touched by Justice Ohri. There is one aspect that whether Chapter 5 is an addition and POXO or is it substituting. This we will all need to examine, because the sections of POXO have shifted and the punishments have been introduced in the Bharatiya Nyaya Sanhita from section 63 to 69. The aspect of community service also was mentioned, which is one of the punishments added under section 4. The only thing is that section 4, community service, is added only for 6 specific offences. What I wish to say and would want all of you to, at a given appropriate time, insist also is, our courts were never reluctant and never went to resort to community service as a punishment under their extraordinary and inherent powers. And we have in the past had trees were being planted, people were asked to carry out, teachers were asked to carry out redeeming classes for the students, etc. So community service, or to even stand at the signal to manage the traffic, these have all been done under the inherent powers. Using community service only for 6 of the time offences, or would we be able to, in appropriate cases, seek the indulgence of the court to have community service as a punishment? Because if in the recall that in the trial courts there would also sometimes beseech the indulgence of the court or TRC, as you call it, or any such punishment which is felt appropriate. When the concept has changed from Dand Sanhita to Nyaya Sanhita, then Nyaya is a much wider word. So what we need to understand is that what is the intent of the legislature to have Nyaya for this society, or go back to the colonial times and have Dand as the method of deterring people. When the theory of reform is to be adopted, then community service and such other like punishments need to be more acceptable and more widely given, rather than putting people behind bars and making them hardened criminals. There is one significant addition in the ambit of abatement. Today, abatement goes beyond borders of India. Under section 48 and 148, even those who are abetting offences in India will be equally liable, and they cannot escape the territorial limits of the application of the today's IPC. Because Bharatiya Nyaya Sanhita acknowledges that cross-border abatements, cross-border instigations and aiding of offences is carrying on. So you cannot hide behind the fact that I am not within India, so your law is not applicable to me. That will no more be a shield. That is a significant move, and it will have to be examined by all of you whether the Israel case, as I have mentioned, where they picked up people because they were abetting the terrorism from cross borders. Another aspect is that today, for the first time in the penal statute, in the Nyaya Sanhita, there is a leniency given to the first timer in an offense. Consider it could be a case of what we call as counsels a crime of desperation, a crime which happened in the heat of the moment. So this, where this degree has been given, where the first offense and the second offense are stated, is an acknowledgement of the fact that the legislature acknowledges today that crimes are not always premeditated. It could be a crime of desperation, and in law colleges we used to be given an example that you cannot compare a premeditated murder with a crime which a street vendor, if you pick up a fruit from him, even at 2 rupees pinches him. And he wants that his 2 rupees back as paid, and a person quarrels on it and he lifts his whatever knife or something he has to get his money back. It's in the heat of the moment, and because of his status, for him a 2 rupee loss is a big loss. So that crime of desperation has been considered, and theft, there is a distinction under section 303 which has been drawn, the first time offenders and offences which are committed as the second time, etc. '69 was quoted by Justice Ohri, but the interesting part is the explanation in '69. Deceitful means, which has been added as an addition to promise to marry. So kindly note that it is not only a promise to marry which is defined separately, but deceitful means includes even promises for employment or promotion or marrying by suppressing identity, which is the love jihad as we commonly read. Deceitful means does not include, according to my submissions, promise to marry, because it is separately defined. Let us not confuse ourselves that deceitful means includes all this. Deceitful means and promise to marry both have been added in '69. Deceitful means would be giving the casting couch, as it used to be called. That promise, that allurement, all that is included in this deceitful means. Now, why I have added this slide is only for the reason that there is a slight distinction. Snatching is something which anyone who has been to a police station would find that there is a big chart put. Snatching is a law and order problem that makes the life of a common man unsafe. So snatching has been specifically defined separately, and the punishment in this is 3 years and fine, instead of theft which has 3 years or with fine or with both. So here they have mandated a sentence. He cannot get away with just a fine. This is one of the distinctive features which I could find after Justice Ohri had taken everyone through the details. The menace hit and run, what I was mentioning was, please have the clause 2. The clause 2 is taking care of the hit and run. So you are not providing medical care to that person. Whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to a police officer or a magistrate soon after the incident. So this is taken to 10 years. From what was 2 years and a bailable offence, that is removed. Now I wish to draw everyone's attention to this part. We are all students of law. So let us first understand, when any enactment is enacted, there is a preamble to that enactment. Bharatiya Nyaya says it's a consolidating amending act. If it is a consolidating act, then all other statutes on the same subject should be merged in it. But unfortunately, the sections Bharatiya Nyaya Sanhita do not reflect that. Every act is defined in the 113. Now, I would like to invite your attention to the last explanation after clause 7. For removal of doubts, it is hereby declared that the officer not below the rank of superior police shall decide whether to register under this section or under unlawful activities. Are we going to allow our liberty to at the mercy of a superintendent of police? Is something which all of us need to think. And why I say so is, my co-speaker could hold himself and but I can tell all of you, it would be better to have Bharatiya Nyaya Sanhita govern us than these special statutes, because Bharatiya Nyaya Sanhita, the provisions of liberty enshrined under the BNSS, Bharatiya Nagarik Suraksha Sanhita, allow bail on the same pattern as it stands today, that is, without any twin conditions or rigors which are added to the statutes. So if you are having a consolidating act, then one of these days, one of us will have to rise and say, how can you invoke a special statute which is prior in point of time and BNS being created and enacted at a later point of time, and interpret it in a manner that BNS should rule and prevail? Now that is something which will be a debatable issue, but I wanted to highlight this, that once the preamble says consolidating act, how can you allow an SP to decide under which section he is going to prosecute me? Organized crime, Justice Ohri has already taken you through. This is again something I would say that if I have to suffer the 111, the organized crime, then I'd be still safer and ask for get my bail on the existing law as it continues. Justice Ohri has already talked of second treason. One aspect is lynching. This is something which has been brought in as a new aspect. The difference here is, if you see 1031, that's what has been so. But the second clause is specifically added for the hate crimes. And the hate crimes could be in any of the category. So if you read 2, when a group of 5 or more persons, so it's basically going on the concept of that there is a mob, or what we call as 149 unlawful assembly, which is added. 147, 149 of the today's Act. When a group of 5 or more persons acting in concert commits the murder now on the grounds of race, caste, or community, personal belief or any other similar ground, he will be punishable with death or imprisonment for life, which shall also be fine. Punishment remains the same, but this is probably I would compliment the legislature for recognizing that a common refrain of the defense counsels is, what was the motive? हम क्यों मारते इसे? So absence of motive is taken care by bringing in all these grounds that these could be also possible grounds. To that extent, I compliment the legislature for thinking that much. Beggary also, Justice Ohri has taken care. I would not like to detain you. Now, this is the last part of the Bharatiya Nyaya Sanhita, 358. Now, again, as lawyers, what you need to understand is what the general clause allows and protects. The first clause says IPC is hereby repealed. Unless you read 2, IPC stands repealed. Now, 2 protects certain things. Notwithstanding the repeal of the code, referred shall not affect the previous operation of the code. So repealed or anything duly done or suffered thereunder. Right, privilege, obligation, or liability acquired, accrued, or incurred under the code so repealed, or any penalty or punishment incurred in respect of any offences committed against the code so repealed, or any investigation or remedy in respect of any such penalty or punishment or any proceeding investigation. What you need to examine in this, and I am, as Justice Ohri rightly said, we are all students of law. We are still coming to dig into it, understand it. If an offence is not discovered, would it be covered under B or not? Is a for thought. Generally, a proceeding pending is protected, or an offence is not discovered. In what? Or overlap of offences. An offence starts from 29th of June and continues till 2nd of. What will be the status? Will you consider it as a part of the first date because the offence has started on that day, or when the offence completes on 2nd of July? What will be the status? These are challenges which will be thrown up. Bharatiya Nyaya Sanhita is not to go alone, go with Nagarik Suraksha Sanhita. So the procedure which is required to try these, because what is the offence? It is an offence in the books, but unless and until I know the procedure to bring me to the books, is something which all of us will have to examine after we read Bharatiya Nyaya Suraksha Sanhita. And what will be the cases of overlap? Another aspect which you will have to see is an offence similar to 377. If it is deleted, would the mollification of sentences, the reduction of in the new act, will that benefit go to the individual in terms of T. Barai's judgment, or one will have to go through the same rigors as it stands today prior to 1st of July? Will also be one aspect which will be probably a food for thought for all of us. And lastly, I'd like to remind everyone that as students of law, You will have to see when new section is brought. All the statutes like organized crime, Mokoka is brought in here as organized crime. In Mokoka, you have to seek permission of a joint commissioner, deputy commissioner. That permission here, there is no provision for that. In terrorist acts, again safeguards are there. Those safeguards are all missing. So one will need to see whether in the absence of the safeguards, do we read those safeguards into BNS, or we need judicial pronouncements to read those safeguards into BNS? Will be a chapter which all of us need to examine. And with that, I don't want to detain you or your evening. Thank you very much.
Thank you so very much, sir, for insightful words. Now, I invite another nominated senior to the floor to address vote of thanks.
Thank you, Beni. A very good evening to all. Thank you all for being here. It was a houseful, more than a houseful, in fact. It was a pleasure seeing all of you here, and the function was primarily because of your presence here, and your presence here in large numbers only shows your keenness to learn and to improve your skills and knowledge in making this episode of Learning the Law a huge success. We'll continue with this endeavor of ours to have more of these lecture series in future so that we have more participation and more clarity in sessions of law. Well, today also was a very exceptional day for another reason. For a change, Mr. Jatin Singh opened the innings today. With normally he ends the innings. And also say that he mentioned that he had big shoes to fill in. I have even bigger shoes to fill in. He has been remarkable at giving thanks. That was his forte, and probably for the last 5 years he's been doing that. And thank you, Jatin, for giving this opportunity to me. Giving the vote of thanks. And thank you so much, Jatin, for your warm welcome to the panelists and to the. We will hope to have more of these from you in future. Thank you so much, Justice Ohri, for taking out time from your tight schedule and insightful and informative presentation on the new act, which is still quite alien to many of us. Well, some doubts have been removed today. I'm sure each one present in the hall and watching it on digital media would highly appreciate the ease with which you have clarified and explained the final aspects of the act. The full House bears testimony to your popularity and zeal of the bar members to hear and learn from your experience both on the bench of the bar. Hope to have you back soon, very soon amongst us for another topic. I'm sure you will take that also from us. Well, Mathur, I don't have the words to explain, but he's the treasure trove of legal knowledge, who has graciously agreed as a leader of the bar to lead us from that share his vast knowledge and experience with us. Thank you so much, Mohit, for giving us such a presentation. Certainly, we all, especially younger members of the bar, would highly benefit from the insight shared by you this evening. It was very, very informative. I'm sure more. And we will. And dynamic you are, would lead the bar with great example. Thank you, Mohit, so much. In the evening from 94, famous industrialist Motors, he says, anyone who stops learning is over, whether at 80 or at 20. Any learning stays young. The greatest thing in life is to keep your mind young. So, keeping that in mind, it will be our endeavor at the Bar Association to organize many more such sessions, learning the law and keeping you all young. more than mine and yours. Last but not the least, I thank all members of the association who have been closely associated with this successful completion of today's function, which has been very aptly hosted by Mr. Benipal in absence of our secretary, Sandeep, who was unfortunately away for a family commitment. Thank you, Beni, for this good thing. See you all very soon for another session and join us for tea at the now. And we will be announcing
I will add one thing, Mr. Alal, that these days when my code I ask any council or where what is come to life mention the section number. I won't like you. I won't be remembering that by section number. Let me what happens. Otherwise, your pain will be dismissed.
हेलो प्लीज लाइव लाइव बस 1 मिनट में बंद कर देना रुक जाओ कॉल पे रहना अरे मैंने सेंड तो कर दिया है Just wait. End कर दो। हाँ बंद कर दो लाइव बंद कर दो ठीक है